Dr. Melo, you are still under oath.
Yes, Chair.
The other day, sometime early this week, this is, I'm continuing with my advice. Sometime early this week, there was an expert who was testifying and clearly enjoying her field, just as you do yours. And then she would give an answer and then go into some lengthy explanations. And I said to her, you are allowed to be brief in your answers. So if I say to you, you are allowed to be brief when you answer questions, you wouldn't be the first person for me to so advise. That said, Advocate Schippers, you can continue.
Thank you, Chair. Good morning, Doctor.
Good morning, Advocate.
We're going to go to a different area. We are now going to the disputed messages, H1 and H2. The annexes to the complaint, H1 and H2. I just want to confirm you indicated that what you saw on that page, and Chair, that is in volume 1, page 36. Just tell me if I'm correct, the way that I understood your evidence is that this page is is a screenshot of a WhatsApp message. Is that correct? Depicted WhatsApp. Not necessarily a WhatsApp message, but it's a screenshot taken on WhatsApp. Is that correct?
Chair, I said the picture I see is of a screen of a WhatsApp.
Thank you. But then you said the way H1 and H2 is on here, it's below the, how did you call it, the right typing area.
Yes.
And that, in your opinion, that was a message still being compiled.
I said it could be possible that it could, through your Chair, that it was.
Yes. I agree with you. The complainant's evidence was, or let me first ask you this. You are familiar with stickers on WhatsApp. Is that correct?
Yes.
Is it correct that when you receive a sticker, when you click on it, it gives you 3 options: either save to favorites gallery, or you can, I think you can delete it, but there's 3 options, and then you can save it. Is that correct?
Chair, through you, it depends on the settings as well. Could be possible.
The complainant says when her phone worked this way, when she clicked on it, it gave her the option to save it, and then it was saved in the WhatsApp sticker gallery. Do you agree with that? That is possible?
Chair, I could only work with this. As to what the complainant said, I could only work with this.
Now, I'm asking you, is it possible, the way she explains it? I'm not asking if it was the truth. I'm saying, is it possible?
And I said it's based on the settings. It's very difficult, through you, Chair, to say this is what transpired. This opinion I gave, it's based on this.
Do you understand my question? I'm not asking you for specific that this is exactly why it happened. I'm putting you the version what the complainant said, and I'm asking you, is it possible? Yes or no?
I would have to confirm that.
Don't you know if it's possible or not?
As I said, it depends on the settings.
And if the settings is set like that, is it then possible?
It could be possible.
Thank you. And do you agree with me, or let me ask you that? That is saved in the sticker gallery in WhatsApp. It's not saved in the photo album gallery on the phone. Is that correct?
In this instance, the setting, if they are like that, yes.
Thank you. Now, the complainant indicated that when she received these pictures, she clicked on it and she saved it to her favorites gallery. You will not know that, but that's what she testified. And when she wanted to take a screenshot in that messages when it came through, the messages were, the stickers were already deleted. And the reason why it's depicted the way it's depicted on this picture is she opened the WhatsApp conversation, the last one that she had with the judge president. She opened the conversation because she wanted to say that these stickers came from him. Then she opened her sticker gallery where these two stickers were to say, in her way of trying to prove that it was him, she took a screenshot there. Is it possible the way she said testified?
Chair, I wouldn't know.
Thank you.
I wouldn't know because, yes, no, I wouldn't know.
You wouldn't know. So just to make it clear so that you also understand, the way it is here is not to say that these stickers were in this conversation. The complainant was very clear. She did not receive it during this conversation on this page. She only wanted to show that it came from the judge president.
I wouldn't know, Chair.
But you also cannot say from whom she received the stickers. Is that correct?
I wouldn't know, Chair.
So you don't know the sender of the stickers. It could be anyone.
I wouldn't know, Chair.
Thank you. Then we can move to K8. K8 is on page 47, Chair. That is the image of the private part. Is that correct?
K8.
Yes, K8.
Yes,
And
yes,
that,
Chair.
am I correct to say that you say that you cannot, on how it's depicted here, you cannot say if it's from a WhatsApp message or not, because the way this photo is taken?
I said through you, Chair, based on the reference of the template I was referring to, it cannot be confirmed if this was on WhatsApp or not,
So it could be from WhatsApp or it could not be. You don't know.
based on the template I was referring to.
And again, on this one, you also cannot confirm whether or not who the sender of this picture was. You don't know.
Based on the template. Thank you. Yes, Chair.
And it is possible, the complainant indicated that she sometimes cropped pictures. When she took a screenshot, she cropped it, so then it's possible that the rest of the WhatsApp message will not be there. Is that correct?
I wouldn't know, Chair.
But it's possible. You can crop a photo, a screenshot, is that correct? To cut out some of the stuff in the photo.
You can.
Thank you. Then we can move to K12 on page 51. According to you, you said that you observed that there was a time lapse, a conversation gap between 8 July 2021 and 28 June 2022.
Yes.
Why do you say that? Because on this picture, I only see 28 June 2022.
On Chair, on the document I looked at, through you, Chair, if I'm following the document correctly, the page before, at the bottom, shows 08 July 2021, that is K11, and then the next page that I got on the document, page 51, which is K12, then I see no other dates before except 28 June 2022.
And you base that on what was provided to you, is that correct?
Yes. Chair, if this, can we all see?
Now, I agree with you, that is
Okay.
exactly how it is. But
Yes.
can I refer you to volume 3, page 1249?
Assist me with the volume.
The Secretariat will come and assist you
Is
now.
this the document? Is this the document?
She's coming to assist you. It's volume 3, Chair. One, 249.
And Chair, may I highlight that I never had the volume before,
Yes.
and I think it might be subjective of me to give an opinion while I had only this document.
Now, I don't want you to give an opinion. I just want to show you it's no fault of your own. On
Yes.
1249, you can see 8 July depicted there. Is that correct?
And-
On that one that I gave you now.
Yes, I just want to make sure that I follow
All right.
the document.
Okay. If you turn the page on volume 3, that one that you have there, do you see 9 July there?
I see. Yes, Chair, I see 8, I see 9.
And if you turn the page, there's 12 July.
12 July 2021.
So because you did not have the complete set, you thought that there was a gap in conversation, but actually there was no gap. Do you agree with me? And it's no fault of your own. It was not provided to you.
And it's difficult to really, because as I said, Chair,
I think what
Yes.
the advocate is telling you is
Yes.
that he's showing you that there were some communications in between.
okay.
Yes,
Yes.
that's correct. Then we can turn to K13 on page 52. You testified here about the fact that there was only one tick. That means it was not delivered. You recall that?
And Chair, if I may also to say, the screenshot I observed through you, Chair, that I don't see time,
Yes.
I don't see other attributes related to the template that I was referring to.
So this could also have been cropped. You don't know.
I wouldn't know.
You wouldn't know. Now, the complainant's evidence regarding this was, at this stage when she sent the message, she agrees that the respondent, the judge president, did not receive it because he already blocked her at that stage. You cannot dispute that. We agree with you that it was not delivered.
I wouldn't know through you, Chair.
Thank you. We can then move to Annexure N. That's on page 58. The way it's depicted here, you indicated that this looks like she, the complainant, forwarded this message to someone else because the you was on top of there. You don't know, but it looks like that.
Chair, through you. I said there's a possibility that you could have, or you could have forwarded, or it could be your own typing comment. So there's multiple possibilities.
That is aligned with what the complainant testified. Her testimony was that she received this picture from the respondent. You would not know that. You don't know who the sender, the original sender of this picture is. You don't know. Is that correct?
I don't know,
Thank you.
based on what I see here.
Yes. And she received it from the respondent, and then she wanted to send it to a colleague of hers for safekeeping. And then she wrote the words no comment on the bottom and forwarded it to her colleague. That's consistent with what you see here. It's possible.
I wouldn't know.
It's possible.
I wouldn't know what would have happened.
But it's possible the way she described it.
Say it one more time.
That she forwarded to a colleague and she wrote the words no comment on it. It's possible.
Yes, it's possible.
But again, you don't know who the original sender was.
I wouldn't know.
Maybe we can go to Annexure P. That's on page 61. Again, here you say it's not consistent with the screenshot of a WhatsApp because all the features are not depicted on there. Is that correct?
Yes.
But you can also not dispute that it was received on WhatsApp.
I wouldn't know.
You also don't know who the sender of that picture was.
I wouldn't know.
And it could have been cropped or saved in the gallery. You don't know.
I don't know.
Then I just want to finish up. What you testified here, your expertise relates to technical transmission of WhatsApp and the Unicode. Is that correct? In relation to the tribunal, that's what your evidence is about. How they are sent and received, and it's not in regards to social or linguistic interpretation.
Chair, as I said, I never claimed to be a linguist expert.
So your evidence speaks to functionality and not the meaning of the messaging, the conversation. You cannot give an opinion on the conversations. Is that correct? And what the meaning of the conversations was.
I said, through you, Chair, that I looked at the usage of emoji and in line with Unicode, ascribed keywords definition. That has been my position.
Thank you, Doctor. I have no further questions. Thank you, Chair.
Chair, may I also appreciate the questions? And there's one question that was asked that related to JP said, do you agree or not? I based my opinion on what is in line with the Unicode and the keywords aligned, ascribed to it. Being pulled into the merits of the case I think that we'll leave it to the tribunal. Thank you, Chair.
No further questions. Thank you, Chair.
Mr. Madonsela.
Thank you, Chair. When you were dealing with cropped, what the evidence leaders says it's cropped images. She made reference to K13 amongst others. I don't want you to go there, but I want to ask you something about cropping. Can you explain in technical terms, if you can, what cropping means or what it involves?
In simple terms, through you, Chair, it can be done on any computer device. But in this instance, you take a picture, or you grab, as a simple terms, you grab it, then you shorten it or you cut it to the size of what you want. It can be a photo in your photo gallery. It can be on the screen. It can be anyhow. So that's what cropping would mean.
If you crop a picture or a message, is it possible to superimpose things on the picture that you have cropped?
When you say superimpose in simple terms,
To manipulate the picture, in other words.
because it becomes, through you, Chair, because it becomes an editable photo, you can put a comment on it, you can write on it, you can squeeze it whichever way you want. Depending on the software that you also use, you can edit.
Thank you, Chair.
Dr. Millo, just one question for you, please.
Yes.
You mentioned Unicode and Emojipedia.
Yes.
We have a list of emojis and definitions in Unicode.
Yes.
Would I be correct to say there is also a list or meaning of emojis in terms of Emojipedia?
To answer you, what Emojipedia does, they consider the background of when the emoji was added or the version of the emoji, and they then, in consideration of the meaning allocated by Unicode Consortium, the technical team, and then with their own also augmentation or supplementation, they, out of their own opinion, would say in the social media, there's also this kind of usage, but it's just their own opinion in terms of that. Yes, I hope I can. It's clear.
Thank you. No further questions. Thank you.
Thank you, Dr. Melo. You are excused. Thank you for your time.
Yes, and I really appreciate and all the best to the tribunal. Thank you. Okay, thank you.
Advocate Madonsela.
Thank you, Chair. May I have leave to call the next witness, Ms. Onati Sogoni. For purposes of this witness, may I please ask the tribunal to have regard to respondent's bundle, page 340. I know. And this one.
This is
The longer statement? The longer statement? No, the one. No, the longer statement. One that I-
Mr. Matonsela, you say page?
340. Sorry, man. 348. It's volume 1, respondent's bundle. Badly, yes. Chair, so that I avoid any further disruption with regard to identification of documents, might I please ask that those assisting the tribunal members also pick up another volume, volume 4 of the respondents bundle, and in particular, pages 1676. Can I continue, sir? The witness will testify in isiXhosa and through the medium of an interpreter. I see, Chair, you say I must proceed. I think it is usual that the witness be sworn in first.
Yeah. Thank you for reminding me, although I'm not sure I had forgotten. But, ma'am, your full names, please.
Khawusipha amagama akho onke ke nefani.
Unathi Sokoni,
Unathi Sokoni.
Yes. Do you have an objection against taking an oath?
Ingaba unengxaki nokufunga okanye nokuthatha isifungo?
Andinangxaki.
No objection, Chair.
Do you swear that the evidence you are about to give will be nothing else but the truth? And if so, would you raise your right hand and say, "So help me God"?
Ingaba uyafunga ke uba ubungqina bakho buya kuba yinyaniso yonke, nyaniso yodwa. Uba kuya kuba njalo, sicela uphakamise isandla sakho saseright uthi ndincede Thixo.
Ndincede Thixo ndithethe inyaniso.
Sworn in, Chair.
Thank you. Mr. Madonsela.
Thank you, Chair. Mr. Sogoni, where do you work?
Usebenza phi, Ms. Sogoni?
Uqala kwam usebenza ndasebenza eSpringbok eNorthern Cape
My very first time of employment, I started at Springbok in the Northern Cape.
ngo-2008 as a DCRS clerk.
That was in the year 2008 as a DCRS clerk.
And then,
What is DCRS?
Ima.
okay,
Intoni ke i-DCRS ngamafutshane lana intoni yona?
digital
It's digital
court
court
recording
recording
system.
system.
And now you work, where do you work?
Ngoku usebenza phi ngoku ngawo lo mzuzu?
Uqala ngo-2019 kuzotsho ngoku ndisebenza eMakhanda High Court.
Starting from the year 2019 up to date, I am working at the Makhanda High Court.
As a CRT clerk or
There,
stenographer.
there I work as a CRT clerk or stenographer.
Stenographer, I think there's an easy one.
It's rather stenographer. Let's stick to stenographer, Council.
Yes. We're saying before you were employed at Makhanda as a stenographer, you worked elsewhere, where?
Uthi ngaphambi uba ube usebenza eMakhanda, ubusebenza phi kanene?
Bendisebenza eSpringbok kwa-Department of Justice. Mara ndisebenze kwindawo ezahlukeneyo, kwii-sections ezahlukeneyo, kwiminyaka ehlukeneyo.
I was working in Springbok in the Department of Justice. Even though I was there, I was placed in different sections in the department,
Yes, in the department, yes.
different offices
Sections.
or sections rather.
Yes.
Can you just tell us, under what circumstances did you transfer or did you become employed in the Makhanda?
Khawusichazele ke ukuba kufikelele njani okanye bekuphantsi kweziphi imeko apho uye wakwazi into yobana uzibone ngoku sowusebenza eMakhanda.
Okay, kwa-Justice eSpringbok ndasebenza kakuhle kakhulu eNorthern Cape.
In the Northern Cape under the Department of Justice, I was working very well.
Qha ngenxa yezinto ke zobomi ndifuna utshintsha ubomi after ndidivosile ndifuna ubomi uqala ubomi obutsha.
Due to life changes, I needed to also start afresh as a result of also the divorce that I had gone through. I therefore decided to start a new life.
Now, you then came back and worked at Makhanda High Court as the stenographer, as you said.
Waze ke ngoku wazokusebenza apha eMakhanda njenge-stenographer njengoba busutshilo.
Yes.
Yes.
And when you worked at Makhanda, did you have any interaction with the complainant in this case?
Ngeli xesha usebenza apha eMakhanda ke ngoku, ingaba ukhe waba nalo unxibelelwano phakathi kwakho nalo ufake isikhalazo?
Ewe, saba ngabahlobo ngo-2019 ufika kwam.
Yes, we became friends in 2019 upon my arrival.
I'd like you to talk to the tribunal and tell us about your interactions with the complainant in this case at some length. But before I do so, Chair, with your permission and the members of the tribunal, I need to address a matter that is not related to the issues in this case with this witness, which she has asked that we should address upfront. On the 2nd of June,
I was just wondering,
sorry, Chair?
I was just wondering, when you say you want to deal with a matter which is not related to this, I don't know exactly what word you used.
Yes, Chair. For the record, on the 2nd of June, and we have
I'm
placed,
not sure whether we should get into the 2nd of June. Let's clarify that first part, the introduction you made. It sounded as though you were saying, let me deal with a matter which has nothing to do with these proceedings.
oh, no, it has, which has got nothing to do with the merits of the case, but it has everything to do with these proceedings. I'm sorry.
Except the merits.
Yes.
All right. Before. There are too many.
Chair, I would suggest that we do this discussions in chambers.
Yeah, yes, I was about to ask him, Mr. Madonsela, whether this is not a matter or part of the matter we actually discussed in chambers and agreed to deal with it in the manner that we agreed it should be dealt with. Is it not part of that?
It was not indicated to be dealt with in chambers.
Sorry?
It was not indicated that it would be dealt with in chambers.
No, there are certain issues that arose. We received correspondence.
Yes.
Prior to the commencement of these proceedings.
Yes.
Correspondence which raised some issues and accusations and counter-accusations and the like. We then dealt with those things in chambers on Monday. Is it not part of that?
Chair, I don't remember this one being dealt in chambers. I might be wrong.
Well, of course, you were there in chambers. We will be guided by you, but what I'm saying is that I hope you will bear in mind certain agreements that were reached in chambers. But if you feel that it does not fall within that area, well, that's up to you. But I would be profoundly disturbed if we are going to find ourselves dealing with the issues that were exchanged during correspondence, which I thought were settled in chambers on Monday.
Chair, I will.
Okay.
Sorry, I didn't.
Yeah. The panel.
Chair,
panel.
Sorry.
So if you want to deal with that matter, you know better than we do. Out of caution, the panel would like to adjourn and that aspect be raised in chambers.
I agree, Chair. Is that when these proceedings commenced on Monday, the first thing that the evidence leader placed on record in public was that there has been an allegation of threat against the complainant, referring to this witness. And this witness deals with...
No, Chair, I
No.
never said it referred to this witness. I said we don't know who the threat came from. We don't know the origin of the threat.
No, we know the origins of the allegations.
No, we don't.
We have them on the 2nd June letter.
No, I think we adjourn. Please, let's meet in chambers. We adjourn.
other people.
Okay, let's not get into those details. Let's deal with the times when the two of you were friends.
Masingangeni ke kwezo nkcukacha okwangoku, kodwa masingene ke kulo mcimbi okokubana ngela xesha beningabahlobo. Sake sijonge apho kuqala.
You said you arrived in Makanda in 2019.
Uthi ufike eMakhanda ngomnyaka ka-2019, kunjalo?
Ewe, Chair.
Yes, that's correct.
And when you were friends, did you have any discussions about your relations with the judges?
Ngela xesha nanisengabahlobo, nanikhe nayo na incoko ngokuphathelene nobudlelane kwi-judges ezi?
Ewe, kuba sasizitshomi sasincokola.
Yes, because we were friends and we will have conversations.
What?
Can you just stop there for a while? Mr. Madonsela, you finish us with a statement by the witness.
I did.
Yes.
There are two, in fact.
Sorry?
There are two statements. The one at 348
Mhm.
and the other one at 1676.
16
76
in your bundle.
in respondents bundle. The one is 348 is in volume 1 of
Yeah,
the
that
respondents
one I
bundle,
have.
and there's another one in volume 4 at page 1676.
Another one was circulated. Billion. Oh, no, it's the same thing. We would like to read these statements, for which purpose we adjourn proceedings, and let it also be tea time for everybody. We will resume at 11:15. We adjourn. I understand you were able to retrieve the part that we asked you to play earlier on, which you are not able to do so. If you are ready to play that part, please do so.
Thank you, Chair. We are ready to proceed. However, I just want to place on record that there has been parties involved in threats and counter-threats. Both are parties to this tribunal, but I don't think it's necessary for us to go into the details. There has been a criminal case has been opened with SAPS, and they are investigating it. So I'm just informing the tribunal that there has been threats and counter-threats, notifying you, but I don't think it's necessary for us to go into details of those threats.
Yes, to put it more accurately, as we receive it, there are allegations of threats and counter-threats.
That is correct, Chair. And then there was just a preliminary factor that needed to be dealt with. There's a question whether or not the
I think that's enough. Yes, we believe that that situation must obtain, and we are not going to deal with those allegations and counter allegations. We are not the right platform for that. According to the papers or letters that have been written to us about it, it's clear that some criminal charges have been laid. Maybe I should say counter criminal charges have been laid. So that's the right platform to hear and inquire about such things. Thank you. So you heard that, Mr. Mendoza?
As the court pleases.
Yes.
As please, Chair.
Yes. Yeah. That said, we have had time to read the two statements made by the witness. We have a provisional or prima facie view about her evidence. Our prima facie view is that her evidence, she cannot lead evidence on the contents of these two statements. And if you want to persist to lead her evidence on the contents of this document, you have to make out a case for that. We are of the view that large parts of it are hearsay evidence. That's the first point. Secondly, there is evidence on the character of a person. This is character evidence. Thirdly, the contents of these statements have not been put to the complainant when she testified. Fourthly, and this is very problematic, because of the nature of its nature, the contents of these two statements are going to cause more difficulties than that. In ordinary legal language, we say the probative value of the contents of these statements is so minimal in relation to the inquiry that we are supposed to conduct. And in that sense, therefore, technically it's irrelevant. So, Mr. Skakani and the other parties, I hope you're listening, and that is the point prima facie view we're taking. The contents of these two statements are not admissible for the purpose of these proceedings. And if you want to persist with that, Mr. Madonsela, you may have to, I don't know, you have to bring a substantive application or whatever, I don't know, but that is our prima facie view. If you want me to summarize again?
No. I've heard every word.
Yes. Yes, when I spoke about the probative value, I should have added that it would be prejudicial to the complainant, the contents of these. And the prejudice that would occur to the complainant in this case, when you compare it with possible probative value of this statement, the prejudice far outweighs any probative value of this statement. And as I said, it's technically irrelevant as a result. It raises more problems than at any value to our mandate. Mr. Madanser.
Chair, may I please ask on your precursory statement that it is a prima facie view that you hold. In relation to that, I understand it to mean, and I'm asking so that I get clarity, if you are open to persuasion otherwise.
Well, you see, we cannot, having looked at these two statements, take a final decision without hearing you. That's why we speak of prima facie value. We don't believe in miracles happening, but miracles do happen. Things do happen that you least expect. You may be able somehow to persuade us, but it would not be correct for us to take a final decision without hearing you first, and also hearing from the other side. That is why we prefer to use the word prima facie.
Chair, I do not propose that we spend a lot of time on this determination on this issue, in the sense that you should provide us a longer period of time to prepare substantive application to motivate that you should hear the evidence of this witness, at least in some part, or maybe a narrow part. I do propose, Chair, with your permission, and members of the tribunal, that I make 2 or 3 points, very brief points, on it, and then leave it to you, in considering those points, to decide whether you are persuaded or not persuaded.
And the purpose.
Immediately, yeah?
Sorry,
To do
I
so
interrupted.
immediately.
Sorry.
To do so immediately.
Oh,
That is my proposal.
yeah. Well, of course, if you are ready to deal with the issues that you have raised, you can proceed.
Yes. Chair, thank you, Chair. I just want to deal in motivation for you to hear the small part of the evidence that I will allude to now, which will be given by this witness, and address myself to its relevance, and also to deal with the prejudice that it might cause to the complainant on the basis that it was not put to the complainant. Those 2 aspects. Let me start with relevance. Miss Lisa Vetten, came here in this tribunal and gave evidence to the effect that the complainant was subjugated because of the power positions of her as a secretary, a child secretary, and because the JP was a judge and a father. That she described as the reason why she was subjugated, and as a result, responded to the JP, the manner she did, with deference. That's the essence of her testimony. She based that on theories about power relations, without having heard a word with the complainant. She was allowed to give that testimony. How can we be forbidden? How can it not be relevant for the respondent to give direct evidence relating to how the complainant understood the relations between her as a secretary and the judges, as related to her by the complainant? I asked that question argumentatively. I'm not asking that they should respond to it. I'm asking it to make the point that in our submission, in order for us to deal with that evidence in a direct way, the evidence of Miss Mango, the evidence of Miss Sogoni, as to what the complainant said to her about those relationships between secretaries and judges, is directly relevant to deal with that theory of Miss Lisa Vetten. That is in relation to relevance. And that is all that I need to put on record through this witness about what Miss Mango understood the power dynamics between them as secretaries. She and secretary. The complainant, as advised by Miss Mango, what she advised her on how she should relate with the judges in the division and where power lay, as she understood it. She being Miss Mango. That is not hearsay evidence. This witness is going to talk about what Miss Mango directly said to her on that direct topic. So we say it's relevant. There is, we accept, prejudice to the complainant because that version was not put to the complainant and was not dealt with in the presence or maybe during the time that the witness or the complainant was testifying. That's true. But we've got two answers to that. Firstly, of course, it was not put to the witness or to the complainant because we were content with dealing with it at that stage without any need to call Ms. Unati Sogoni, because it could be dealt with through cross-examination of her own evidence without the need of calling a witness on that topic. But the real reason why it arose sharply that we should call this witness was because Miss Lisa Vetten was called very late in the day when all the other witnesses had testified. Her summary was only provided to us when all the witnesses had testified. I mean, the evidence leaders, witnesses. So we had no way of knowing that the issue of power relations will arise. Nowhere any time before the complainant testified. So we could not have put that version because we could not anticipate that Lisa Vetten will come and say that. As it were, to embellish the complainant's allegations that she had power, there were power dynamics. So, Chair, it is unfair to us to be settled with a situation where you allowed, despite our objections, Lisa Vetten to come later in the day with a late summary in such circumstances where we cannot deal with her evidence. It's unfair to us. It is, in fact, prejudicial to us. So we say, on that score, to ameliorate the prejudice that may arise, it is not the kind of prejudice that cannot be assuaged or remedied by recalling the complainant in relation to those issues. If it becomes so important for the evidence leader and for this tribunal to do justice to the complainant and put these versions to her, that is the proper course, rather than excluding evidence that is relevant to a matter that has been raised late in the day by the evidence leader without us getting adequate opportunity to deal with it. So, Chair, as to probability of value and how you evaluate the evidence at the end of the day, it's a different matter. It's a matter that arises once the evidence has been heard and once the witnesses have testified, and you are at the point of weighing which version you should take and which one is more probable. It does not arise in our submission at this stage to determine whether the witnesses should address that particular matter we're talking about. So, say we submit in essence that you should revisit your prima facie view on this topic and limit the evidence of Ms. Unathi Sogon on the narrow issue of what she understood the power relations to be between them, her, as secretaries, vis-a-vis the judges in the division. On that narrow issue. All other issues we do not wish to pursue with on the basis of a prima facie view. So it is on that narrow basis that we invite you to reconsider your prima facie view and consider our argument on this score and allow the witness to testify on that issue alone. And that issue, Chair, just to deal with the point that you raised as to the character of the evidence or the nature of the evidence, we say that that issue is not and does not raise character issues on the part of the complainant or any other person involved in the statement. That is not the kind of the evidence that will deal with the character of the complainant, in the sense that it will not raise more difficulties, as you put it, Chair, in relation to other people who are not connected with the case. So, Chair, we say that this evidence should not be excised from the record. It should be allowed. It's relevant. And it's any prejudice it might cause can be assuaged by ways that will limit the extent of the prejudice by recalling the complainant. Thank you, Chief.
Just for clarity, are you saying that if she were to testify, it would only be on one aspect and one aspect only, namely, as you put it, the issue of power relations?
Yes, only that.
Now that would be, assuming that's the case, it would be then a general testimony on the concept of power relations.
I don't know.
Because here in these statements are pointedly dealing with and directed at the complainant. It's not a general discussion of relationships.
Yes, it will be pointed in relation to the complainant only. Her, the complainant's understanding of the power relations, not other people.
That's just the clarity I wanted. And then I'm not sure what you mean by saying that the issue of power relations was raised for the first time when Dr. Vettel testified.
No, I'm not saying that it arose for the first time. I'm saying it was embellished by her through her.
But it has always been a central issue from the beginning.
Chair. Yes, it was a central issue from the beginning. I may have forgotten to raise this issue. Let me raise it now that you have made an inquiry about it. You will recall, say, and the members of the tribunal, that when my learned friend, Mrs. Kakane, entered into a debate, because Chair, I suppose and I surmise that when you say it did not arise only when Ms. Witten came through, you are in fact saying that it arose when the complainant testified. I'm making this submission on that surmise. When Mrs. Kakane delved into the cross-examination of the complainant on what he referred to as a core construction of power, he was stopped. And it was suggested at that point that that issue will be dealt with by an expert, Ms. Lisa Witten. So he did not proceed to engage with that debate through the complainant. And that issue only crystallized once Lisa Witten's report was filed. When it was filed right at the end of the evidence leaders' witnesses, when all witnesses had come and gone. So, Chair, it may have arisen, but it was not pursued and ventilated properly with her because it was suggested at that time when Mrs. Kakane raised the issue of core construction of power and theories of power, that that issue must be raised with Lisa Witten, who was to come in a later time. So, Chair, you're right. It was always there, but it was not allowed to be pursued sufficiently as it arose when Ms. Lisa Witten came to testify late in the day. So the point I'm making, Chair, if I don't want to be like witnesses who continue answering questions, even if they have been answered. The point we're making, Chair, is that the issue could only be dealt with properly once Lisa Witten's report had been filed.
Just another thing first, remark that I've got to make, because I think my colleagues may want to ask questions for clarification. I've read these two statements. I'm unable to say they are actually just about power relations. But I can confidently say that these statements are about the complainant. They're not dealing with the concept of power relations in the manner that you're suggesting Mrs. Vettel did.
Chair, you say that it's not only, you are right, it's not only about that. There are other aspects that deals with the character of the complainant. But those are not the portions I wish to lead here on. I wish to lead here on the topic, one topic, of relations between secretaries, admin staff, and judges.
Yes, but
I'm
sorry, that's the premise of your proposition. But I'm saying to you, the contents of these statements do not deal with the issue of power relations between judges and clerks. They deal with Mrs. Mengo, her life, her sexual life, and many other aspects of her life. The contents of these two statements, or rather, your argument, you premise your argument on the theory of power relations. The contents of these statements don't deal with the concept of power relations. They deal with an individual person, Mengo.
They deal with relations between secretaries and judges. And I'll limit that debate to paragraph 9 of the second statement. Because, Chair, you'll recall
Paragraph what?
9
Of
of the statement at
the typed version.
Typed version is
Paragraph
1677.
9.
Because, Chair, Ms. Lisa Vetten came here and theorized based on WhatsApp exchanges that the complainant was a child secretary facing a father judge. How can it not be relevant to that topic to lead evidence that deals directly with how Ms. Mengo understood the relationship that she should have or she can have with a father judge? How can it not be? It is, we submit, relevant.
Are you finished?
Mr. Matonsela, if, let me put it hypothetically, if we were to accept your argument that paragraph 9 is the one that is relevant to address the question of power relations, are you saying then everything in this affidavit is to be excluded then, as you lead this witness?
I would abandon it.
But this statement or this paragraph is just a two-lined paragraph.
Yes,
Are you only going to lead here or expatiate on this particular paragraph?
that I'll just lead on it.
Thank you.
Advocate Skippers, are you ready to respond?
I am. I know Advocate Buttender also wants to respond. I'm of the view that it is not relevant. These lines in here is totally different than what the case is before us. Because it's not the case, as it's stated here, that the complainant was a seductor. Nothing like that was ever laid or put to the complainant. And it is not correct to say that power relations only came up now with Ms. Lisa Vetten's evidence. It was from the beginning, even in the first proceedings, that was part of the case of the complainant. So I'm of the view that it's my submission that it is irrelevant and should not be allowed.
Advocate Butland.
Thank you, Chair. Chair, the argument we've just heard is worrying on many levels, but let me just try to deal with what we've heard. First of all, the oversimplification of Ms. Vetten's evidence is concerning. Her Ms. Vetten is an expert. She was acknowledged to be an expert. The preeminent expert on gender, I think, was put to her even by the respondents. Ms. Ogoni is not an expert. She's not an expert on gender. She's not an expert on power imbalance. And you do not need, this panel does not need to know about power dynamics from someone who we know has a fractious relationship with the complainant. That is clear. So I would submit that you've already had evidence that deals with that. And you've had evidence, we heard that the respondent's concern with this witness was to place evidence before this tribunal that concerned the relationships between secretaries and judges in this court. You've already had 3 witnesses come and tell you about that, who are actually secretaries. Ms. Ogoni is not a secretary, she's a stenographer. You've had Brenda, you've had Abongile, and there was one other, Zinhle. So I would submit that to the extent that the respondents wish to place this evidence before you, it's already before you, and it's before you from people that actually have first-hand knowledge of that relationship. They all gave evidence about the dynamics between secretaries and judges, and particularly about the judge president. Secondly, it's not true that the respondents were only told about the power dynamic imbalance when Ms. Vetten's evidence was canvassed. That's not true. Ms. Skeepers dealt with power dynamics in her opening statement. Mr. Skakane cross-examined on balance of powers. It's not true that he was stopped. Before he was stopped, he cross-examined extensively, and I've just checked our notes, on overt power and soft power, for example, on photographs. So there was a lot of questioning, in fact, of the complainant about power dynamics. So it was prefaced right from the beginning. The complainant was only asked about certain things theoretically. She was not asked about the things that this witness wants to come and give evidence on. The respondents were given ample opportunity to get their own expert. We adjourned at the last session and we gave them an opportunity to find their own expert and tell this tribunal if they had a difficulty doing that and needed more time. They did not. They chose not to. And I'm not suggesting that Ms. Vetten's evidence came early. It did not. I can't suggest that. But that prejudice was cured. We specifically talked about curing that prejudice by affording the respondent an opportunity to get an expert. That would have been the appropriate way to test her evidence. They chose not to. Then I heard a suggestion about recalling the complainant. Well, there have been many times when I've thought that the complainant should be recalled because there are many things that were not put to the complainant. And if this complainant is recalled, then I will submit that she must be asked about all of those things. If the process is to call her back, then all of the things that she was not asked about, that this tribunal heard evidence about, must then be put to her, and she must be given an opportunity to contradict that. But with all due respect, the evidence that this witness seeks to give is neither relevant nor is it necessary for this tribunal because you've already had enough evidence on that specific question, and you've had it from people that actually have first-hand knowledge and do not have any question about having a fractious relationship with the complainant. So I would submit that the panel is correct to regard this evidence as inadmissible, and I would submit that we would agree with the panel. Thank you.
Thank you. You want to respond?
Very briefly, I just want to say, to put it on record, that I can understand when Advocate Bartlander, SC, takes the position she's taking to protect her client. I don't understand why the evidence leader will be belligerent on this aspect, because this affidavit of Ms. Sogan was given to the evidence leader long before the proceeding started. And she never pursued it. In an inquisitorial inquiry such as this one, it was incumbent upon her to at least deal with the allegations that Ms. Sogoni dealt with in her affidavit before this proceeding started. She didn't pursue it. So she can't complain about that. Well, if the complaint is to be recalled and has to deal with everything else, well, so be it. It's the choice of the evidence leader to deal with it. But that's the only way you can cure prejudice that will occur to the respondent if direct evidence relating to the complainant's understanding of her relations, how she relates with the judges, is to be led by a witness. That's the only way you can cure that prejudice, if it arises at all. We had no obligation to deal with the opening statements which were made by the evidence leader in this case, by way of cross-examining witnesses and impute on them the evidence leader's understanding of what the case was all about. We had to wait for witnesses to come and testify to that effect. And Ms. Vitton came, as I said, late in the day. So we're in that position, Chair. We need a ruling on this point. We will accept whatever outcome you put to us. But it will be unfortunate if we submit. If evidence that is critical to the assessment of Lisa Vetton's assertion is excluded, it will be a sad day. Thank you, Chair.
By the way, just refresh my memory, if you did answer to this question. Why was this not put to the complainant? Paragraph 9. The
Chair.
contents of paragraph 9.
Chair, when Mrs. Kakane was dealing and delving deep into the matters that dealt with power relations, co-construction of power and power theories, before he could even get into that point, his cross-examination was objected to firstly by the evidence leader and the complainant's legal representatives. And that objection was upheld. He never got to deal with that issue. He left it for the right moment.
May I ask Mr. Madonsela, this is evidence. This is not theory, as you say that Mr. Sekakane was discussing with the complainant. This was direct evidence. I mean, if what she said here is direct evidence, one would expect you to put that to her.
It's evidence relevant to power dynamics. It's evidence pertinent to power dynamics, which was canned right at the start. I don't know why my learned friends say that Mr. Kakane was not stopped. The record is clear that when Mr. Kakane delved into the theories of power, developing the argument, it was the complainant's legal representatives, or maybe the evidence, well, I'm saying those seated on the other side. I see Ms. Butler is shaking her hand. Those seated on the other side jumped up and said, well, she doesn't know anything about power relations. Deal with that with the expert witness. So the matter was left at that point before Mr. Skakane could delve onto the question.
So the answer you are giving to my question, why was this aspect not put to the complainant? Your answer is that we stopped Mrs. Kakane. Is that your answer?
No, the answer is it would only arise in the context of a power relations. And since that power relations argument or cross-examination was stopped right at the start, it was never dealt with.
Chair, can I please just, I don't want you to make a ruling before I have a chance just to respond to that. I said when I addressed you that I'd looked at our notes. It's correct that I objected to Mr. Skakane's line of questioning. And Mr. Skakane continued questioning. In fact, he continued on things like photographs and talked about very specific things related to balance of power. And so I would simply ask this, if that's what you're going to make a ruling about, then I would ask that you go and look at the transcript of what happened then, because we disagree that Mr. Skakane was not allowed to cross-examine on that issue, and that my objection stopped him from doing that. It did not. Thank you.
Thank you. I think all set, I think we will adjourn and to go and consider the issue. Maybe we should just adjourn and hope for the best that we'll be able to come back at 1 o'clock. An hour from now, maybe.
Chair, Chair, maybe before you address us, may I just find out, Chair, what is anticipated will happen today? It's a Friday, and are we going to go up until the usual 3:30? Are we going to break early? I just need that clarity so that we arrange our affairs this side.
Assuming that we rule against you, what would be the implication? Is there any other witness?
Yes, the respondent is here to testify.
Oh, okay. Would the respondent have been ready to, excuse me, not respondent, would you be ready then to let the respondent commence?
The respondent is ready, has been ready to testify, but my other friend, Mr. Mskakar, might not be so ready. I don't know. He may have to talk for himself because he is leading the respondent. I think there is an element of readiness. I think he can respond on his side.
Yes, Mr. Skakan.
Yes, Chair, it's just a practical issue. We can start. What I see, looking at the themes I'm dealing with the respondent, we may have to start and stop quite too early in the themes that he's dealing with. So while he's ready, we are ready. I think practically, unless we could start on.
Stop at 3 or 3:30, it won't really matter.
Um,
If the issues that, there are issues that you could deal with until 4 o'clock, there are issues you could deal with until only 3 o'clock, then that's fine, or 3:30, that's fine.
It's,
That's what Mr. Sikakona says. He doesn't think he'll finish in that time.
Yeah,
I think I need a day or two.
definitely.
But I just think practically we're gonna start with something and end. So if the tribunal is ready to start on Monday morning, I could do that. But I'm in your hands. I'm in your hands. I just think practically it may work better to start on Monday when I'm going to do it for the whole day with her. With him. But I'm truly in your hands. Just practically, I would like the tribunal to make a ruling. We both ready, but I just think, and also the other thing may be that we may actually need to adjourn to line up documents, and so I do think we better off starting on Monday. But my client will kill me for this suggestion because he's ready. But I think practically he is not a lawyer. I'm the lawyer now, so I think practically I will be in your hands. But we can start on Monday.
Yeah. Yeah, I think we should adjourn and then come back. Yeah, let's adjourn, we'll come back at 1 o'clock. We adjourn. Yeah. We're advised lunch is ready, so everybody can go for lunch now, and then we'll come back at 1 o'clock. We adjourn.
Thank you, Chair.
Thank you. Do I speak to Mr. Skakani, I guess now? Mr. Skakani?
Yes, Chair. Yes.
Well, yes. Is there another witness for the
Chair,
respondent?
as I said, the next witness is the respondent himself.
Yes.
And as I said, if the tribunal wants us to start, we can. If we start on Monday, we can.
Yeah,
It may be an exercise in futility because I may actually recover what I'm going to do on Monday, but I'm in your hands.
no, that's fine, unless advocacy person, advocate Barrenda insist we start now. We would find it convenient to stop now and start on Monday with the respondent.
I don't insist us starting now, Chair, or continuing now. I think we are all tired
All
after
right,
this week.
yeah. We will, however, start at 9:30 on Monday. And we would like to finish the evidence, all the evidence by Thursday next week. And to that end, we would like to suggest that, as I've said, we start 9:30 on Monday and then sit until 4:30 each day with the hope of finishing by Thursday. Now that's 9:30 every day until 4:30 from next week.
Thank you, Chair.
Am I excused, Chair, just for clarity purposes?
Oh, yes,
Am I excused?
you are excused.
Thank you.
I've been mistaking you for a witness. You are excused.
Oh.
Well, Advocate Mashawa reminds me that you are excused. Perhaps depending until next week.
Not a problem. The officer has covered that anyway.
Yes. Yeah, with you, the advocacy keepers will discuss that because we don't know. Maybe the complainant will be here and want to translate into isiXhosa. Maybe the JP may exercise his constitutional right to say he testifies in isiXhosa. So the safest thing is just for you to be here 9:30.
Surprises.
Yeah.
No problem, Chair.
Well, Chair, I'm working on his proficiency in English. We will try. Thank you.
We adjourn until Monday 9:30. Thank you.